In this video, I'm going to explain why you need to stop filing multiple LLCs in Florida. The 2026 Florida Horizontal Shield is here. And by the end of this video, you'll understand exactly what a Protected Series LLC is, how the new Horizontal Liability Shield works, and why this single change could save you tens of thousands of dollars in fees while giving you even stronger asset protection than what you have right now. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've spent decades helping business owners protect millions of dollars in assets, and I can tell you firsthand that this new law is the most significant change to Florida business structuring in years. All right, so here's the situation. If you own multiple businesses or multiple properties in Florida, there's a very good chance you're paying for 3, 4, maybe 6 or 7 separate LLCs right now. Separate filings, separate registered agents, separate annual reports. It adds up fast. And starting July 1st of 2026, you may not need to do that anymore. Let me paint a picture for you. Imagine for a moment you're a real estate investor. You own 5 rental properties across South Florida, and your attorney told you years ago to put each property in its own LLC. That was good advice at the time. It created a wall between each property so that if a tenant sued over one property, the other 4 were protected. But here's what that actually cost you. 5 separate filings, 5 separate annual reports at over $100 each, 5 separate registered agent fees, and 5 separate EIN applications, 5 separate bank accounts, and depending on your CPA, 5 separate tax returns. We're talking thousands of dollars every single year just in maintenance costs. Now, for a larger portfolio with 10 or 15 properties, you could easily be spending tens of thousands of dollars annually just keeping those entities alive. Now, multiply that across the hundreds and thousands of business owners in Florida who run multiple ventures. Think about the entrepreneur who operates a consulting firm, a real estate portfolio, and an e-commerce brand. That is 3 LLCs minimum, 3 of everything, 3 sets of compliance headaches. The old way worked, but nobody is saying that it did not work. But it was expensive, and it was redundant, and frankly, it was inefficient. Florida recognized that, and Governor DeSantis signed a bill that changes everything. Last summer, Governor DeSantis signed Senate Bill 316 into law. This legislation adds uniform Protected Series provisions to the Florida Revised Limited Liability Company Act under Chapter 605 of the Florida statute, and it takes effect July 1st of this year. All right, so what does it actually do? Well, it allows a single parent LLC to create multiple internal divisions called Protected Series. Each series can hold its own assets. Each series can have its own liabilities, and each series can have its own members and managers. They operate independently under one umbrella entity. Think of it like a building with separate apartments. The building is your parent LLC. Each apartment is a Protected Series. A fire in apartment A does not burn down apartment B. A lawsuit against one series did not reach the assets of another series. The separation is what Florida law calls the horizontal shield. Now, let me explain why that term matters. Well, you already know about vertical protection. That is standard LLC protection. It shields you personally from the debts of your company, your personal home, your personal bank accounts, your retirement funds. Vertical protection keeps those safe from business creditors. Now, the horizontal shield is different. It runs sideways across your business structure. It keeps Protected Series insulated from the debts and obligations of the other Protected Series and from the parent LLC itself. So creditors of Series A cannot reach the assets of Series B. Creditors of Series B cannot reach the parent. The wall runs in every direction. This is the same concept that states like Delaware, Texas, and Illinois have offered for years. But Florida business owners had to form those entities out of state and then register as foreign LLCs here. And that created its own complications and costs. Now you can do it domestically, right here in Florida, under Florida law, with Florida courts backing the structure. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now, here's where most people are going to get into trouble. The horizontal shield is powerful, but it is not automatic. You do not just check a box and walk away protected. The statute is very specific about what you have to do to maintain that shield. First, you need to file a Protected Series designation with the Florida Department of State. That public filing formally creates each series and puts third parties on notice that your LLC operates under a Protected Series framework. Each series must include the parent LLC's name plus the words Protected Series or the abbreviation PS in its name. Second, you need unanimous member approval to create a protected series unless your operating agreement explicitly allows for a lower voting threshold. And third, and this is the big one, your operating agreement must be detailed and thorough. It needs to spell out the rights, powers, and duties of each series. It needs to cover the allocation of profits and losses. It needs to address accounting and record-keeping procedures. And this operating agreement becomes the backbone of your entire structure. And fourth, and I cannot stress this enough, you must maintain separate, contemporaneous records for each series and for the parent LLC. And these records must clearly identify the assets associated with each series. And they must document the liabilities and obligations of each series. And they must identify the members and managers of each series. If you fail to maintain those records, the shield collapses. A creditor can argue that there was no real separation between your series, and a court can pierce through that horizontal shield and expose all of your assets across every series, including the parent LLC. We're talking about potentially millions of dollars in exposure for a business owner who simply got lazy with their bookkeeping. This is not optional compliance. This is the price of protection. Separate books, separate bank accounts, separate documentation for every series. If you commingle funds or blur the lines between the series, you are inviting a creditor's attorney to tear the whole structure apart. All right, so who should actually consider this structure? Let me give you a few examples. The first and most obvious group is real estate investors. If you hold multiple properties, this is built for you. Each property goes into its own protected series. One liability event at one property stays contained. Your entire portfolio does not go up in smoke because of a single slip and fall lawsuit. Now, the second group is entrepreneurs running multiple ventures. Maybe you have a consulting practice, a restaurant, and an equipment leasing operation. Instead of having three separate LLCs with three sets of everything, you have one parent LLC with three protected series. Same protection, a fraction of the administrative burden. Now, the third group is family offices and investment groups managing diverse asset pools. You can segregate different investment strategies, different classes of assets, and different risk profiles all under one entity. The flexibility here is remarkable. And the fourth group is any established business owner who is tired of paying tens of thousands of dollars a year to maintain a stack of separate LLCs that serve the same basic function, asset protection. Now, here's an important caveat. The structure is not for everyone. If you have a single business with a single line of revenue, a standard LLC is probably still your best option. The Protected Series LLC makes sense when you have multiple distinct activities or assets that carry different levels of risk. The law does not take effect until July 1st, but that does not mean you should wait until July to start thinking about this. Now, if you currently operate multiple LLCs in Florida, now is the time to evaluate your entity structure. Talk to your attorney, talk to your CPA, and determine whether consolidating into a Protected Series LLC makes sense for your specific situation. And if you're forming new entities between now and July 2026, keep this framework in mind. You may want to plan your structure around the ability to convert it into a Series LLC once the law does take effect. And if you're operating a Series LLC in a different state like Delaware or Texas and doing business in Florida, pay attention. The new law also establishes clear rules for foreign LLCs registering in Florida. The recognition framework is now in place. The businesses that will benefit the most from this law are the ones that plan ahead, not the ones scrambling after the effective date, trying to figure it out. Florida's new Protected Series LLC law is a game changer for business owners who manage multiple ventures, properties, or asset portfolios. The horizontal shield gives you real liability separation without the cost and complexity of filing entity after entity after entity, but only if you do it right. Now, if you found this video helpful, make sure to hit that like button and subscribe to this channel. I break down the most important Florida business law developments so you can protect your assets and grow your business the smart way. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.